In this episode, we begin by looking at one of the most practical parts of risk management, because security work does not happen in a vacuum, and it never exists apart from rules that come from outside the technical team. A new learner can easily think cybersecurity is mostly about threats, controls, and incidents. But the reality is that organizations also have to obey laws, satisfy regulators, and honor the promises they make in contracts. That is why this topic matters so much for the certified in Risk and Information Systems Control (CRISC) mindset. Risk professionals are expected to understand not only what can go wrong, but also what the organization is required to do when protecting data, delivering services, working with customers, and partnering with vendors. When you understand these requirements clearly, you stop seeing compliance as a side issue and start seeing it as part of the full risk picture that shapes priorities, decisions, and accountability across the business. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyberauthor.me in the Bare Metal Study Guide series. A helpful starting point is to separate legal, regulatory, and contractual requirements, because beginners often blend them together as if they are one big category of rules. Legal requirements come from laws passed by governments, and those laws may apply because of the country, state, industry, or type of data involved. Regulatory requirements come from agencies or authorities that are empowered to interpret, enforce, or operationalize laws within a specific sector, such as banking, healthcare, utilities, or privacy oversight. Contractual requirements come from agreements the organization has signed, which means they are not always written in law, but they still create real obligations with real consequences if the organization fails to meet them. That distinction matters because the source of the requirement affects how it is enforced, how it is interpreted, and what kind of remedy follows a failure. A legal violation may lead to penalties or lawsuits, a regulatory failure may trigger audits or sanctions, and a contract breach may create financial damages, lost customers, or termination of a business relationship. Once you see those categories clearly, the next question is why risk managers care so much about them. The short answer is that requirements define the boundaries of acceptable behavior for the organization, and those boundaries shape what risks matter most. If a company stores medical information, payment data, or sensitive personal data, the risk is not just that attackers may steal it. The risk also includes fines, reporting obligations, customer harm, reputational damage, contractual penalties, and business interruption that follow when protected information is mishandled. Requirements turn abstract technical problems into business problems with measurable consequences, and that is exactly the perspective that CRISC expects. A weak access control is concerning on its own, but it becomes much more serious when the weakness could violate privacy law, fail a regulatory expectation, or break a customer commitment. In that sense, requirements give risk language more precision, because they connect a control gap directly to legal exposure, compliance pressure, and business commitments the organization must keep. Another important idea is that requirements rarely apply evenly across an entire organization. A beginner might imagine a single rulebook that covers everything, but most enterprises operate across multiple jurisdictions, business lines, and service models, which means different parts of the business may face very different obligations. A hospital, for example, will care deeply about health privacy and care delivery regulations, while a payment processor will focus heavily on card data standards, fraud controls, and financial oversight. A cloud provider may have one set of obligations for its own internal operations and another set flowing down from contracts signed with enterprise customers. Even a company with one product may face different requirements depending on where its customers live, where the data is stored, and who its subcontractors are. That is why risk professionals spend time identifying what laws, regulations, and contract terms apply to which systems, processes, datasets, and third parties. The work is less about memorizing every rule and more about mapping obligations to the actual business activities that create exposure. Legal requirements usually feel the most formal to new learners, because laws carry the weight of government authority and can affect the entire organization even if the security team never reads the statute directly. Privacy laws are a good example because they often govern how personal data is collected, used, shared, protected, and retained. Healthcare laws may require stronger safeguards for protected patient information, while financial laws may require careful record-keeping, resilience, reporting, and fraud prevention. Labor laws, consumer protection laws, breach notification laws, and records retention laws can also influence information security decisions in ways that are not immediately obvious to a technical team. A system design choice about logging, data deletion, or customer authentication may look purely operational at first, but it can quickly become a legal issue if it conflicts with statutory obligations. For that reason, risk managers need to know when an issue crosses the line from a control weakness into legal exposure and when specialized legal counsel must be brought into the conversation. Regulatory requirements add another layer because they often translate broad legal expectations into practical oversight. In heavily regulated sectors, regulators may publish guidance, examination criteria, reporting expectations, and control themes that organizations ignore at their own peril. The organization may not be told exactly which technology to buy or which setting to enable, but it may be expected to demonstrate reasonable safeguards, documented governance, effective monitoring, and timely response when issues appear. That means a regulator is often less interested in whether the team uses one specific tool and more interested in whether the organization can show consistent discipline and responsible control over risk. A bank that cannot explain its access management practices, third-party oversight, or incident escalation process will have a hard time convincing a regulator that risk is being managed responsibly. Risk professionals therefore pay attention not only to what the rule says on paper, but also to how the regulator evaluates evidence, how often examinations occur, and what kinds of findings tend to matter most. Contractual requirements are sometimes underestimated because they can look less dramatic than laws or regulators, but they are often the most immediate source of pressure in day-to-day business relationships. A contract may require uptime levels, security reviews, encryption, breach notification timelines, audit rights, data deletion rules, subcontractor restrictions, insurance coverage, or specific reporting obligations after an incident. If an organization signs those terms, they become enforceable commitments regardless of whether the legal team or security team fully appreciates the operational burden at the time. A customer may care less about the exact regulation that applies and more about whether the company met the promises written into a service agreement, data processing addendum, or confidentiality clause. This is especially important in vendor and cloud relationships, where responsibilities are shared and assumptions can become dangerous very quickly. A missed notification deadline or failure to meet a promised control requirement may not make national news, but it can still trigger dispute costs, lost revenue, damaged trust, and contract termination at exactly the moment the organization can least afford it. It also helps to understand the common documents where contractual requirements show up, because risk managers often encounter obligations long before they see a courtroom or regulator. A master service agreement, MSA, sets the broad business terms between parties and may establish liability, dispute handling, confidentiality expectations, and overall responsibilities. A service-level agreement, SLA, narrows in on measurable service commitments such as uptime, response time, support windows, and availability targets. A non-disclosure agreement, NDA, focuses on protecting confidential information, while data processing terms may define how personal data is handled, secured, and returned or destroyed. Security addenda often include promises about access control, encryption, logging, incident reporting, employee screening, or audit cooperation. The key lesson for beginners is that these documents are not just paperwork sitting in a folder. They describe business promises that create risk if the organization cannot actually perform them in real life, which is why security, procurement, legal, privacy, and risk teams all need to stay connected. At this point, a useful question is how these requirements actually influence security decisions inside the organization. They affect control selection, policy wording, retention schedules, vendor reviews, training expectations, incident response planning, and even how systems are designed and documented. If a contract requires customer notification within a very short window after a security incident, the organization may need faster detection, better logging, and a more mature escalation process than it would otherwise choose. If a privacy law limits how long data can be stored, teams must think carefully about backups, archives, analytics environments, and forgotten datasets that accumulate over time. If a regulator expects separation of duties, stronger review processes may be necessary in finance, administration, or privileged access workflows. In other words, requirements are not just something to check after a system is built. They should shape planning before a service launches, because retrofitting compliance after the fact is usually more expensive, slower, and more disruptive than designing with those obligations in mind from the beginning. A common beginner mistake is assuming compliance automatically means security, as if passing an audit or meeting a formal requirement guarantees protection. In reality, compliance and security overlap, but they are not identical. An organization can satisfy a minimum requirement on paper and still be exposed to serious threats because attackers do not care whether the checklist was completed. On the other hand, a technically strong control environment can still create risk if the company fails to document it properly, follow required reporting rules, or honor what it promised in a contract. CRISC thinking requires holding both truths at once. Compliance gives a baseline of expected behavior and evidence, while sound risk management looks more broadly at what could cause harm to the business. The goal is not to worship the checklist or dismiss it. The goal is to understand where formal requirements set the floor, where the business may need to go beyond that floor, and how to explain the difference in a way leadership can understand. This is where governance becomes important, because requirements do not manage themselves, and they do not belong to only one department. Legal counsel may interpret laws, compliance teams may coordinate assessments, procurement may negotiate terms, privacy leaders may handle data obligations, and security teams may implement or monitor controls. Even so, none of those groups can succeed in isolation if the organization lacks clear ownership, communication channels, and decision authority. Risk professionals help connect those moving parts by translating requirements into business risk, identifying who owns which obligation, and highlighting where gaps or ambiguities could cause future problems. Good governance also means keeping an inventory of applicable obligations, updating it when business conditions change, and ensuring that policy statements match what teams can actually do. If contracts promise one thing, operational teams do another, and leadership assumes a third version of reality, the organization is already carrying avoidable risk before any incident even happens. Third-party relationships bring all of these ideas together in a way that makes the topic very real. A vendor may process sensitive data, host critical systems, provide software components, or support an essential business process, which means the organization inherits risk through dependence even when the technology is not fully under its direct control. Legal obligations may still apply to the organization as the data owner. Regulators may still hold the organization responsible for oversight, and customers may still expect the organization to keep every contract promise regardless of which vendor was involved. That is why strong contracts, due diligence, and ongoing monitoring matter so much in vendor risk management. A company should understand what the vendor is required to do, what evidence supports those claims, how incidents are reported, and what happens if the vendor uses subcontractors or changes services over time. Requirements are only useful if they can be enforced, monitored, and aligned with the actual dependency the business has on that third party. When incidents happen, legal, regulatory, and contractual obligations become urgent very fast, and this is often where students first see how interconnected the topic really is. A data breach is not just a technical containment problem. It may trigger breach notification laws, regulatory reporting, insurance obligations, customer notices, board escalation, evidence preservation expectations, and contract deadlines that begin counting down almost immediately. If the organization has not clarified those obligations in advance, valuable time can be lost while teams argue about who must be informed, what threshold triggers reporting, and which facts are required before a notice can be sent. That confusion creates secondary risk on top of the original incident. A mature organization therefore treats requirements as part of incident preparation, not as a legal appendix to be reviewed only after something goes wrong. Risk managers contribute by helping ensure the organization knows its triggers, responsibilities, decision paths, and documentation expectations before the pressure of a real event exposes every unresolved assumption. For exam purposes and for real-world judgment, it helps to focus on the reasoning pattern behind this topic rather than trying to memorize endless examples. When you see a legal, regulatory, or contractual issue, ask where the requirement comes from, what part of the business it applies to, what obligation it creates, who owns that obligation, and what risk follows if the organization fails to meet it. Then think about evidence, because many requirement failures are discovered not only through an incident, but through an inability to prove that controls, decisions, and oversight actually exist. Documentation, policy alignment, exception handling, and clear accountability all matter because they turn intentions into defensible practice. A contract promise that nobody can operationalize is dangerous, and a legal obligation that nobody has mapped to systems or processes is equally dangerous. The strongest learners keep the business perspective in view, recognizing that requirements influence risk appetite, control design, vendor decisions, and response planning all at once rather than sitting in a separate compliance bucket. By the end of this discussion, the big idea should feel much more grounded and much less abstract. Legal, regulatory, and contractual requirements are three different sources of obligation, but they all shape how an organization must manage risk, protect information, and fulfill its responsibilities to customers, partners, regulators, and the public. A strong risk professional does not wait for an audit finding, a lawsuit, or an angry customer to discover what the organization was supposed to do. Instead, that person works to understand the obligations early, map them to business activity, clarify ownership, and make sure commitments can be supported by real controls and real processes. That is the habit CRISC is trying to build in you from the beginning. When you can connect requirements to business impact, operational reality, and accountable decision-making, you are no longer just learning compliance language. You are learning how disciplined risk management helps the organization stay trustworthy, resilient, and prepared under pressure.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.